Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Sometimes it's just slow, like I am some days. Hi, everybody. Hi, Carla. Oh, the names are back. At least for now. Shirley Temple, I know. Actually, I'm afraid to shake it out because I just did my hair like this as part of my beauty boot camp that I'm putting myself through to be able to effectively put myself together more than I normally do, but I am 1,000% afraid to shake it out because I'm pretty sure it'll just go straight. Now, I've been to the hairdresser many times, and do you know what the hairdressers do after they do this? They brush it or they like finger comb it, and then all of a sudden, and they go, and maybe they spritz, and then all of a sudden it's perfect for like 3 days. And you're like, how the fuck? Do I have the same tools? I don't think I even have the same tools. It's a conundrum that like I'm there. The hair is attached to my head. I've been there every single time I've gotten my hair done. Every time. I've been there. I don't feel like I'm missing a crucial step, and yet I think it's a skill thing. I think it's skill. Regardless. So, see, this is, okay, so this is, it'll look like a little more, I don't know. I fucking don't know. Hi, Victoria. Hi, Courtney. I'm gonna spritz. That's what they would do. I love you guys. I hope that everybody's doing well. Welcome to Sunday Court Watchers Anonymous. I am KCC. I forgot who I was. I am KCC, and I am addicted to court. I'm a digital hoarder, and I hoard court. I scoffed the other day at somebody. Do I? 3 months. Thank you so much. I scoffed at somebody the other day when I was talking to them. They were talking about videos, and they said they had deleted videos. I can find them again. I said, well, that's not true with the types of videos that I have, which sounds like a hoarder justification, but it's also true. Sometimes the court isn't able to be gotten again. If somebody finds a way to make sure we get it all, let me know. I would love to know. Anyways. Oh. Thank you again for the support. Oh, look at that. Thank you. And thank you again. I appreciate that. Why don't we get to some of that court hoard that I've been talking about? Magical. I was wearing a completely different outfit today, by the way, but the green screen, it's white. It's a white shirt. And you know what the green screen does? Erase it. Ponder that one. Like I did. I was so perplexed. I was like, what the fuck, man? That's not even close to green. Like, I bought it specifically because I was like, this will be a safe color. And then, no, it just makes me look like I'm not there, Bill. It's not like X-ray. Anyways, all right, let's get to the court. Remember, we don't require you to stop watching court around here, but oh yeah, that's something else that we're gonna watch, I think, a little bit later. Where's the one that we're gonna watch now? Oh yeah, it's labeled Babels, but originally I saw babies and I was like, oh fuck, it's about babies. Let's go.
In the matter of the marriage of Leandra Babels and Arbery Babels, case number
Quickly,
2019.
my hopes were dashed. My hopes were immediately dashed about the babies. Fucking Babels. Also, nobody here looks happy except for me.
DM 213. Leandra McClure, I think she goes by now, appears by Zoom. Arbery Babels appears from the Butler County Judicial Center's Zoom location. Apparently, this is a hearing set on a motion to enforce parenting time. Mr. Babels, just some initial observations by the court. You filed a motion in this case that you appeared to try to verify, in other words, verify the truth of. But for some reason, you didn't fill out the date that you were verifying that these allegations were true. Was there a reason why you didn't want to do that?
That I think it's not that I didn't want to verify the dates. Are you saying for the parenting going forward from here?
The execution of your signature, right above it, there's a line for you to fill in the date you're doing it. You just glossed over that. Furthermore, it is required that you provide contact information, and the lines are there to fill in. It's very important that anybody who's going to represent themselves follow the same rules that attorneys follow and give contact information, your address, your telephone number, preferably your email address as well. But for some reason, you didn't want to provide that information.
It's not that I didn't want to provide it. I would be more than happy to, and I can fill that in after we leave here. That would be, as trying to file for myself and not being an attorney, that would be a mistake on my part, as just I don't know what I'm doing. I'm just trying to do the best I can.
Okay, and I recognize that, except that when the form itself says name, print, address, city, and telephone, you would think that any common person would know that you've got to fill that in. You can't
Okay,
just ignore it. And that is the signature page of your motion. Page 304. So, I'm just saying that if you're going to file these motions and or pleadings, you need to follow the same rules an attorney would follow and give all of the pertinent information.
Absolutely. And it's
I don't see that you ever gave notice of the hearing to Ms. McClure. Somehow you got a hearing set by apparently calling my assistant, but you have a duty to notify the opposing party of the hearing date and time if you want your motion heard. Ms. McClure, obviously you're very resourceful. You came up with the hearing date and time on your own. How did you do that?
I called the district court clerk and they forwarded me to your clerk and she gave me the date and then forwarded me the Zoom link information.
You shouldn't have to do that.
Yeah,
okay?
no, I did inform her I did not get a notice of hearing with the motion when I got served.
All right, but be that as it may, Ms. McClure has had actual notice of the hearing date and time and she's appeared. So essentially that defect's been remedied by her efforts. This is a motion to enforce parenting time, Mr. Babels. I'm curious about number 2. I last requested parenting time from the other party on 8/8/2025 via Zoom call with Judge Rickey. Is that in a separate case?
So it was during the PFA that she had filed that I was, it was, she was trying to do the PFA, which she didn't meet the criteria. And I thought I had basically, I wanted parenting time for my daughter, which You had talked about that, or said for me to do a motion. You didn't tell me to do a motion, but thought it might be a good idea or urge me. I mean, you can look at the video to file the motion. That's why, I'm doing this. I don't, I'm just trying to see my.
Sir, this is honestly one of the worst pro se appearances I've seen in a while. Not for, it's like he doesn't seem to care that much almost. Like he's like at a meeting and somebody's asking him a question and he's like, this isn't really my project and I'm willing to step in a little bit, but I don't know anything about it. Like those are the vibes that I'm getting. Sometimes people are passionate and so they step all over the court rules and decorum, and that's a little different. He's not really doing that. Yeah, not my circus, not my monkeys. I am a ringleader, though. I will have to admit that.
Daughter every other weekend. Now, if I didn't do the paperwork correctly, we need to start over, I'll do that. Or if I gave the information to the district court clerk in where the glass window is, she said that the sheriff's office would take care of getting her the information, which I put her address, she put on the PFA, which I took most of the information from, which I didn't have before, and tried to, so I assumed the sheriff's office was going to deliver it.
Well,
But
and I think they did, but the point is, they delivered your motion, but no notice of hearing.
okay, yeah, I don't know about that or how that
Again,
works.
if you're going to represent yourself, you have to follow rules. That's
Absolutely,
all I'm saying.
absolutely.
Okay. Let me make sure I understand the situation. There was a considerable period of time, as I try to discern your motion here, that you were apparently working out of state, 5 hours away, I presume would be out of state somewhere. And you didn't see the child for over a year?
So I worked in Phillipsburg, Kansas.
Okay.
So I worked for the sheriff's office up there for a little over a year. And anyways, I had moved up there to try to I knew they were changing sheriffs, so I was going to go for a under sheriff spot. I was trying to further my career, make more money, and get weekends off with the admin position. That didn't work out, and they chose somebody else, and I'm back here in Wichita. But during that time, we had one vehicle, and it wasn't that great. We had 8 kids at the time, and didn't have the money to go back and forth. Now, if I didn't know what I needed to do to reestablish the parenting visitation, or if I could at all. Maybe I can't. I don't. I'm just trying to do what I can.
Okay. Under normal circumstances, Mr. Babels, the court would just expect whatever written orders are on file are going to be followed. But that also presupposes that a parent is exercising or attempting to exercise their parenting time on a regular and consistent basis.
Okay.
The understanding is these will be the orders to be followed by both parties. And you didn't follow it for over a year. And I understand there may be good reasons why you moved and were working 5 hours away in Phillipsburg. But the reality is there was a substantial period of time where there was no father-daughter contact. Now, if anything changes in that year, it obviously has an impact as to whether it's appropriate for you just to show back up one day and resume the prior plan. While I don't necessarily encourage mothers in a situation that Ms. McClure was in not to follow the parenting plan, it hadn't been followed by you for a considerable period of time. So what have you been specifically requesting that you're not getting?
So the times she said I was, in her words, harassing her through different social medias, threatening to take her to court. That was me trying to ask about my daughter, see how she's doing, if I can see her. So during that time, I would have been, the few times I came down, I was willing and able to see her, but she would not let me. So that time has passed because she wouldn't let me see her. because I had to go back to court, which I told her, and she said I was harassing her. So during that time, I would have seen her if I could have, if she would allowed me to. She would not allow me to, and now I'm back to where I'm able to go to court, make the motion. Apparently, I didn't do it right, so if I need to start over, I can start over and do it the correct way. But yeah, I feel during that time I could have seen her if she would have allowed me to. And she said I was harassing her. That was me trying to see my daughter. So
Well, first of all, peaceful communications that are intended just to set up parenting time are not harassment. Okay? You have every right to do that, Mr. Babels, but, okay, the child, I'll call her KIB, all right, is now 9.
Almost.
All right, Ms. McClure, if he's in the area, is there a reason why he shouldn't have his parenting time reinstated?
So the communications that he sent, he last saw Kennedy on April 8th, 2023. He's missed 62 weekends of his scheduled weekends with her. I have the text messages showing of the last time on April 19th, when he said that he would not be getting her because I had asked if he was going to get her on her weekend. She had a soccer game scheduled. He said, no, I'm working both days, and since she has a game, I don't want to get her. Then prior to that, I have multiple circumstances where he didn't show up for his scheduled weekends. In September of 2020, he went all entire month without getting her, emailed my original attorney saying he was going to take me to court because I wasn't allowing him time after that because I had scheduled her birthday party since he didn't communicate. I have text messages from him, but they're not asking for Kennedy. They're asking, hey, how are you? Hey, why don't you talk to me? It's not ever. The only time from April 8th, 2023, April 19th, 2023 is the last text message. And I received no communication from him until November 14th of 2023, when all he said was, how's Kay? And then I got nothing else until January 25th of 2025, when he said, hey, hi, how are you? He did not specifically ask for Kennedy until May 20th of 2025, where he sent a text from a new number demanding Kennedy, but called Kennedy a him multiple times, and said that if I did not give her, he would file a motion. So I had said, I don't feel like that's in the best interests of Kennedy since you haven't been around for 2 years, and I would assume her therapist would agree. So if you feel the need to file a motion, like, that's on you. I do have Kennedy's intake assessment and her therapy notes from her. She's had 2 therapists because her original therapist moved out of the area. But I do have the assessment and the therapy notes talking about Kennedy's anxiety that has stemmed from things she's witnessed from my ex-husband and the attachment issues she has because of that. She is actively in therapy.
All right, what parenting time are you proposing, Mother?
I would be okay with him receiving parenting time, but I would like it supervised to start with until Kennedy's comfortable. Because I don't want to thrust her into a situation where she hasn't seen him in 2 years. She has 2 younger siblings she doesn't even know exist. He's had more kids. She sees his older children from his first marriage. She goes and spends time with them. His oldest is 22 and lives in Mays. And so Kennedy goes over and has sleepovers and spends the night with her older siblings. So I'm not keeping Kennedy from her family. I'm trying to make sure it's in a safe environment for Kennedy not to cause any more issues in her mental health.
Do you know where Mr. Babels is living?
I know he's in Wichita. I've not been there. I have been told it's a 3-bedroom, and I do know that there's 8 children, 6 of which are boys. So that brings up another concern of where is my almost 9-year-old daughter going to be when she's there? In past, a lot of the times when it was his scheduled weekend, he was working. So I'm assuming they're married, his now wife was picking up Kennedy and dropping her off and watching her. I have text messages of concerns where Kennedy had stated she was taking baths with her older brother. When I asked Ryan about it, he told me that what he does on his time is not my concern, and if I have concerns, take it to the court. And I told him, you know, I'm not trying to argue. I'm trying to co-parent effectively. And you being a law enforcement officer, you should know the importance of this conversation. Kennedy would come back dirty in the same clothes I took her in on Friday. I want it to be a healthy, stable environment for Kennedy. I have messages showing where I made the effort of, hey, are you coming to get her? Hey, she has games. In his motion this time, he complained about Kennedy's inactivities and that I want to be there. She's my daughter. Of course, I want to be at her activities. She's been in gymnastics since she was 2 when we were still married. Now she's on a competitive team. She practices 3 times a week. She has meets on the weekends. Like, I don't want to take the consistency that
Humble
I've built
brag.
up with his lack of consistency away from her because he's demanding time with her when he can't be consistent. I'm just concerned for Kennedy not doing well with the inconsistency, because it was, you know, she knew that drop off was every other weekend at 6 p.m. on Friday at Quick Trip. And so I would go to Quick Trip. And then if he wasn't there, I had to explain why he wasn't there. And trying to protect, in 2023, she was 6 or 5. Trying to protect her innocence and not tell her, you know, your dad's just chosen not to show up. I would make excuses. Hey, your dad's at work. You know, something came up. I'm sure he'll reach out and contact me about coming to get you again. But it didn't. I have text messages where I asked if he was coming to get her, and he said that no, he was busy with his wife's boys and he wasn't coming to get her. I don't feel like it's a lack of me not trying. I would love for her to have a healthy relationship with her dad. I would love to be able to have some time without her constantly around me 24/7, but only if it's safe for her and it's consistent.
All right. Where do you live, Mr. Babels?
9436 East Skinner Street, which
All right. Who lives there with you?
my wife Veronica, and she came with 5 boys when we got married. 2 of them have moved over with their dad, so we have 6 children. We have 2 bedrooms upstairs and a bedroom downstairs, and you know, we seem to fit fairly comfortably. We
Where was she
utilize this.
sleep, though, with all these boys there?
Can you turn it up, please? Sorry, hold on just a second. I couldn't hear. What was that?
Where would the daughter sleep?
So I have 2 daughters at home. One's in pre-K, and then the other one's just about to be 2. And there's a girl's room that we were planning on making with a bed for Kennedy. There'll be a bed for my 4-year-old daughter, and then my other little one. I didn't see a problem with that.
All right. And where do you work?
So I worked for At Risk International during the weekends, and I'm a fill-in guy during the week. If people are gone or whatnot, that I think is based out of Virginia, but I'm at the T-Mobile call center there, and I'm the armed security plainclothes. That's what I do there.
Okay, but you work every weekend.
Every weekend I work. Yeah, I can take off days, so I can take off I could work all day Saturday and have off Sunday. I work 2 to 9 p.m. Saturday and Sunday. You know, during my career, I've just always worked weekends. Either for the prison was a Friday, Saturday, or Sunday, Monday. For the sheriff's office, I worked every other weekend, 12-hour shifts. And every other weekend I had off. That worked out pretty good. And this is my circumstances now. Maybe I guess the little time I could get with her or whatnot during the weekend, maybe I if you work during the weekend, maybe I guess it's just too much to have visitation, and because she should be spending time with. I mean, my wife helps out, and we'll go get her and come back, and has been nice. Tried to speak to her, which I think prompted the PFA. Tried to say hello, and then her siblings there. Yeah, we would like to incorporate her into the family and go to the zoo and spend time. And yes, I would have to go to work, but I mean, I've got to work, so I don't know quite
Understood.
what else.
Understood. All right. In what community do you currently reside, Ms. McClure?
I live in El Dorado.
Okay.
Your Honor, can I add something real quick?
Just a moment. You previously had chosen Quick Shop in Benton for
So
your exchange point.
we were originally at Quick Trip in El Dorado because he lived in Eureka. He had told the court when we were divorcing that he was planning on moving to Park City.
Mhm.
The agreement stated Benton would be the drop off. He never moved to Park City.
Well, he's in
And when,
Wichita now, though, East Wichita, so.
yes.
Any
He
reason
is
that wouldn't be a viable exchange point?
in Benton.
Yeah.
Yeah, I'd be okay with that.
All right. Does your child attend church on Sunday mornings?
She does.
Okay, at what church?
We go to Real Life Church on Haverhill.
Okay. All right, so she wouldn't be attending church on Saturday morning.
Correct. Currently, she has gymnastics class on Saturday mornings. She has gymnastics class on Monday, Wednesdays, and Saturdays. The Saturday class can be adjusted if needed. But for me, she was enjoying it. It was something to fill her time.
All right. So when was the last time that Dad really had meaningful parenting time with KI?
The end of 2022, beginning of 2023 was the last time he was somewhat making an effort to get her, but it was still very inconsistent on if he actually took her or kept her the whole time.
All right. This is a less than desirable parenting time situation. This court certainly envisioned both parents being very actively involved at every stage of this child's life, not with long periods of deprivation of one parent from her life. However, the right of the father to parent in this case is not just at common law, it's not just statutory, it's constitutional in nature. And the court doesn't see that Mr. Babels has done anything by way of conduct that would disqualify him from having meaningful parenting time with his daughter. The question is, how do we structure it based on what the court views as new circumstances? And it's generally the court's view that after long periods of separation, there needs to be some reacclimation time before any type of regular schedule is initiated. So this court will order the first visit to be one where the mother is present, but not actively involved in it. And this is how the court structures it. The first visit will be a restaurant visit. Just you and your daughter and the mother. The mother is not to sit at the same table, but can sit close by. I want KIB to be able to look up and see her mom. Okay? I'm not going to necessarily choose a commercial establishment.
Oh, but you fucking know that they will. Sorry, I was getting the shirt that I wanted to put on and see if it still fucks up with the green screen. Also, get your guesses in right now because they are going to choose an establishment. Oh, look at it. See? It offsets that. Sigh. Anyways, get your guesses in the chat. What restaurant will these folks have their glorious reuniting dinner, breakfast, lunch? We're going to talk about it in depth here in a minute. The judge is going to weigh in. He's going to talk about food choice. Huh. You think I'm kidding? I'm not. I haven't seen it yet. I haven't seen it yet. Remember, this is not a custody exchange. Those happen in McDonald's, folks. I guess supervised visits happen at McDonald's too, but I have not yet seen it. All right, we're gonna listen. You guys are gonna feel silly because it's so obvious. It's so obvious. So obvious.
But I've found that this generally works well. It's a relaxed setting. Child gets a meal, can visit with father. Generally about 1 hour in duration is what's contemplated. And just talk to her. Explain your situation, kind of talk to her about what you intend to do during your parenting time that you have with her. And then what the court wants to move to after that, after you've had this reacclimation restaurant visit, and we're going to clarify a time and place on that before we go off the record here. Then the court envisions that you have 4-hour visits, no overnights. I think overnights are simply premature at this point. But I think you ought to be able to spend some quality time with your daughter where you are available, Mr. Babels. So this has to be 4 hours that you're available. Now, before the court was told about gymnastics and church, the court envisioned either Saturday or Sunday, 9 in the morning, which isn't too early for anybody to get to Benton, until 1:00 p.m. That still allows you to get to work by 2. I don't really want to see your work schedule disrupted. That could have some sort of long-term employment issue for you, Mr. Babel. So I really want to see you keep your normal work schedule, but work in a 4-hour period every other weekend that you can spend time with your daughter. So the question for mother is it going to be Saturday from 9 to 1 or Sunday from 9 to 1? Does she miss gymnastics or church?
It's whichever is more convenient for the courts. I can rearrange gymnastics if needed, if it's easier for the courts and him.
Well, quite frankly, in the whole scheme of things, I think the exposure to a religious environment and perhaps some moral environment seems to the court to be, over the long term, more desirable on a regular basis than gymnastics that can be rescheduled.
Absolutely.
So I think we're looking at Saturdays from 9 to 1.
Every Saturday or every
No,
other Saturday?
Every other. She needs to have some Saturdays she can be with her mother. Now this will allow kind of a slow reacclimation, a reintroduction into the father and his new life. I have no doubt that you're going to take her to the house at some point, Mr. Babels, and she can meet and become more familiar with the people there way before we ever consider going overnights on this situation. And this allows you a regular and consistent schedule that you don't have to ask for or fight for. This is a court-ordered visitation schedule that you should be able to plan well on. And folks, I do need you to show up at Benton on time so that the other one doesn't have to wait on both ends of the visit. A question that will arise, however, on the back end. I always want Mr. Babels there at 9 o'clock. As far as the 1:00 p.m., can you commit to always being the transporter, Mr. Babels?
You mean to get her to Benton?
Yes,
I'm
on the
so
back end of the visit.
hungry, and every time he says his name, I think he's saying bagels, and I want a bagel, but a bagel has so many calories. So many calories. So instead we have a bagel. No bagels. Yeah, who is the transporter? A very unique, particular set of skills are needed.
Clock part.
Yeah, I don't foresee a problem. And after that, I can go right to work. So
Okay, all right.
that'll work fine.
Well, that's far more desirable. In fact, that's time you can actually spend with your daughter during the drive. So this seems to be the best manner to reintroduce the father and his situation into the child's life after a long period of separation. Now, this first visit, which we can certainly do on a Saturday,
It's going to be on a Saturday, and none of y'all guessed it right, so get another set of guesses in before we go. What restaurant are these two? Like, can you imagine them fucking? First of all, I need you to imagine them fucking. Because they did. Misery. Do you think the lights were out? They just both look miserable. Anyways, secondly, get your guesses in as to where they're going for this visit. Oh, Chuck E. Cheese is a good guess, Alan, but it is not correct. Not correct. Arby's. They have the meats, but not the meats of these people, I don't think. Sonic, another one. The ice is very good there. Little Caesars. No. There's Crazy Bread there, Nabel. Come on. You can't be having custody things around Crazy Bread. Mr. Gotti's. I have not heard of that, but that's not where it is. No Steak and Shake. Timu, chill out. Although I do love how often you text me. You know, Timu texts me at the frequency I would like somebody to text me. If I liked them.
Morning. What restaurant do you envision, Mr. Babels, that where your daughter would be comfortable? And I'm going to ask the same question to the mother. Somewhere
Does
preferably
the
in
crack?
between your two residences somewhere.
Oh,
Mother, you have an idea?
I don't know. I was gonna say the Cracker Barrel in Park City, but
Mhm.
that's not between.
That's not between, if it's on a morning for, if it's breakfast, she likes pancakes, she likes French toast. She likes anything that she likes to be distracted. She doesn't like to sit still, so,
Okay. Well, this is a one-time deal. I think the
Yeah.
Cracker Barrel in Park City is certainly an appropriate environment. That's a very child-friendly environment. And I think they have pretty good breakfast selections. if I
they
recall.
do. They have good buttermilk pancakes.
Okay. And this first visit will be at the
Not a
Cracker Barrel in Park City.
sponsor.
Again, that's intended to be about an hour in duration.
From 9 to 10.
Yes. And also I think it's pretty well open seating where the mother can get a separate table.
At the
Um,
Cracker Barrel. Explain
and just
that to
kinda
the
keep an eye
Cracker
on
Barrel
things.
lady. Hi, we're here. Hi. Can we get two tables? One within sight of the other? I have a court order. Okay? I have a court order. For some reason, that is so funny to me. Like, you would need to bring a court order into the Applebee's to get or the Cracker Barrel, sorry. To get the two. Oh, God. Could you imagine? Old or new logo? They already got rid of the new logo. Alan? Sashina. Custody at the Cracker Barrel. Don't forget to get a biscuit. Actually, I ate at the Cracker Barrel once, and the apple thing was delicious. Don't sleep on that. It's delicious.
But
Um,
the child sits with dad.
I have a 16-year-old. Is it okay for me to bring him to sit with me?
Yes.
Okay.
I
He's-
don't want him interfering anymore. than I
No,
will.
no, I
Yeah.
just know he'll be like, why don't I get to go to breakfast with
He
you?
gets
Like,
to go.
girl.
You pay for your table and Mr. Babels will pay for his,
Okay.
including the child's. Okay?
What if Kennedy does not want to sit without me? How do I address that?
You're going to be sitting close. She
Okay,
needs to sit with her dad.
okay.
I want them to have, as they eat, they can have
Show
a
her the
discussion
court
between the
order
two of them.
too.
And I think she's old enough to handle it, especially with you sitting so close by.
Okay.
It's meant to create a comfortable situation for her, and you can explain it to her in advance.
Okay.
So when are we going to do this? Sooner the better.
My weekends are open, so
Saturday morning, this
this
Saturday.
This Saturday, the
Yes.
6th,
Yesterday.
that works for me.
You want to set it at 10, 9, 10?
We could do 9.
Okay, 9 a.m. Meet at the Cracker Barrel in Park City. And I think the court set the parameters for how that's to happen. Hopefully she'll just develop a little bit more of a comfort level with dad so that when the 4-hour visits start, which will be 2 weeks from then,
So the
on
20th.
Saturday, then she'll be a little more comfortable about going with dad. And Mr. Babels, you separated yourself for a long time. We can talk about the mother's interference as you seem to suggest by your motion, but the reality is she appears to me to just be looking out for her best interests. And really, we just want everything to go well for her. This is what all of this is about, just making her comfortable. But you do have a right to see her, spend time with her. This time may be expanded at some point in the future, but for now, this parenting plan set today replaces any previous parenting time that the court has ordered. So for now, you have a new temporary parenting plan.
The 28th, sorry, go ahead.
I do have some questions. She starts her gymnastics competition season in December, and normally her competitions are on Saturdays or Sundays. How would you suggest working through those? Because most of them are not in town.
Well,
The original parenting plan states that her activities and school stuff basically trump the schedule.
true, but he had a more liberal schedule then.
Right, right. I just don't want her to have to miss out on things that she looks forward to
Any chance
accommodate
dad would go watch her?
schedule.
I don't
That's up to him. I just wanna, our previous issue with her activities was he wasn't showing up or bringing her on time. And that became an issue, because then she misses out on her activities. So I wanna make sure that she's able, because some of them she has to be in, like last year we had one in Salina where she had to be there at 7 o'clock in the morning.
Okay. Well, do these competitions take both Saturday and Sunday?
No, normally they're Saturday or Sunday. And we get about a week or two before that, we get the time, like the time schedule of when her actual session will be. It's normally a 3 to 4 hour session.
Okay. Well, I don't want dad to miss his parenting time. So if she has a Saturday competition, we'll move his visit to Sunday.
Okay,
If it's on Sunday, obviously the Saturday visit would still take place.
okay. That makes sense to me. Thank you.
You'll need some flexibility on that, Mr.
Yes.
Babel, and I trust the mother will always let you know well in advance that there's a competition, where the competition is, what day it's on, and then you can schedule your weekend parenting time accordingly for the other day if necessary. All right. It's a fair question. After this initial visit, exchange point will be, it's an actual quick shop in Benton.
Benton, there's a gas station right off the highway there.
Okay. You know what station he's talking about?
Yeah,
Nicole?
yeah, it's right. Yeah, it's a quick shop.
All right. All right, that will continue until further order of the court. All right, Mr. Babels, anything else regarding your motion at this time?
The 28th starts the 4 hours. Does that start at 9 a.m. and do we meet at that quick shop?
2 weeks. Want to make sure we're talking about the same dates. The first one is, yes, Saturday the 6th. So your first 4-hour visit would start at 9 a.m. on Saturday the 20th. That's correct. And meet at the quick shop from that point on.
Saturday the 20th at 9 a.m. and then
Back
I'll bring her
to
back
Park
at 1 o'clock. And how long do you want that to go?
I'm not sure what your question is.
Is that my visitation time, the 4 hours
Yes.
to get reacclimated? And how long? Of course, later on, I would want more time with her. I guess I can make a motion. How long would you like to see that go on for?
Well, that varies. each situation is different, and quite frankly, I don't know how this child will adjust to this reintroduction into you and apparently a rather large family units situation. This child is currently working with a therapist.
Ugh. Humble brag. My child sees a therapist. Hi, call-in viewers. Thanks for joining us. I appreciate that. We are watching the tail end of some terrible pro se motion for parenting time. It was quite fun though. They've decided on a time. They're talking about that. And we have one more case after this, but hit the like button while you're here. They're gonna hash out the very end of this. And Beverly, nice to see you as well. If you're new here, go ahead, subscribe. If you've been here before, well, welcome back. It's lovely to see you.
And does Dad know who the therapist is?
No, he doesn't.
All right, well, at that point, the court very well may want therapist recommendations about any broadening of parenting time.
Absolutely.
So I'm not going to put a strict time frame on it because I just don't think I can do that without having some opportunity for both parties to see how she reacts to this.
Sure.
I'm certainly not
Understand.
precluding expansion in the future, Mr. Bagels.
Okay.
I'm going to do that consistent with the best interest of the minor child.
Absolutely. Thank you.
All right, very well. So until further order of the court or the parties agreeing on an expanded parenting plan, which you're certainly encouraged to do, then this 4-hour every other weekend plan will be in effect.
Thank you.
All right. Explore anything else?
Can we address child support while we're
That's
on
not
this?
really before the court today. What's the issue?
Okay,
with
I
child support?
didn't know if it was a part of the parenting plan. He is over $20,000 behind, and he's supposed to provide insurance for Kennedy, and he has not done that either.
Are you providing?
I was actively, we've qualified now for Sunflower Health, but I do have to pay a monthly premium for that as well. So I am providing her insurances.
Good. I just want to make sure she's covered,
Yeah,
Very
yeah, yeah.
important.
I've had her covered the whole time.
especially if she's in gymnastics. Who knows what? will
Yeah.
happen.
Yes, yep. She is just recovered from a broken thumb. So, but not from gymnastics, from a birthday party.
Okay. Sure, there's a story. as to why the birthday party was so violent, but
It was not a coworker, a classmate's birthday party, and there was a trampoline apparently, and one of the other kids fell into her thumb and she broke her growth plate on her thumb. So she's been having x-rays and physical therapy and all of that. So
of course, that is the kind of thing that should be reported to Dad,
absolutely.
just so that he
Yeah.
knows what's going on with her.
Yep.
Okay.
Yep. I planned on making basically here's what's going on with her medication wise, anything like that from now on. But
All right.
I didn't know where he was. He had changed his phone number 6 different times since 2019. So I honestly didn't even know how to give him that information.
But you have
before
that
all of
information
this.
now, right?
I have I believe his current phone number,
Okay.
the most recent one he's texted me from.
Okay. And she can continue to use that, right, Mr. Babel?
What's the last 4 of the phone number?
We're not gonna dox each other. They will though, if I let them, which I won't.
An updated one? Eight 7 4.
406 402.
Repeat it again.
Okay. Good luck in working together for the best interest of your child.
Yeah, good luck.
If there's nothing further at this time, this matter will currently be in recess, and this meeting may be ended for all this time.
Thank you.
Before I go any further,
Yeah, before we go any further with our next case, we have to set the scene a little bit. I was surprised when I got this one. It's not quite as interesting as the last one, but I found it intriguing because the name struck out to me. Jill Gillette is the prosecutor in Kansas, and she seems to be the defendant. Also, Nathaniel looks like John Travolta, doesn't he? Those are the vibes I'm getting already. Did I slow it down? Yeah, I did.
even announce the case, I just want to check with my court reporter who's on the meeting to make sure that audio and video are good for her.
Yes, sir. Thank you very much.
All right, thank you. Court will call the case at this time. Send the District Court of Elk County, Kansas, case entitled Michael Irvy, plaintiff, versus Jill Gillette, defendant, case number 2025 CV1. Linus Baker appears as counsel for Mr. Irvy. Nathaniel Martins appears as counsel for Jill Gillette. I have individual box on this Zoom meeting. Michael, who is Michael?
I know a few Michaels. We've told that story before. But yeah, he's a Timu somebody, you guys. So funny. Nabel, 13 months of support. Thank you so much, baby. Michael, you're gonna have to come on down. You're the next contestant on Judge Ricky's court. What the fuck are you doing here, bro?
Judge, that would be my client, Mr. Irvy.
I just wanted to make sure, clarify that, and thank you for joining the video, Mr. Irvy. Also have someone, Dr. Justin Spees, does not appear to be a party of this proceeding.
He is not.
All right, very well. This is being broadcast on YouTube. I normally don't allow non-party persons to actually join the meeting, so I'm going to ask my assistant to put Dr. Justin Spees in a waiting room. All right. This matter comes before the court at this time on what the court believes to be a motion entitled Plaintiff's Rule 165 Objections and Post-Judgment Motion to Alter or Amend the Judgment, stemming from an earlier ruling that this court had made in the case. The court is aware there's been a response to that motion filed by the opposing party. You may proceed further in regards to your motion, Mr. Baker.
Thank you, Judge. The defendant's motion fails for one simple reason. They filed no affidavit. 65320G requires the court to consider the pleadings and supporting and opposing affidavits. Without an affidavit, the movement never carried her initial burden. The California Court of Appeals in J.V. Mahaffey, 218 Cal App 4th, 1522, 1537, 2013, squarely held that movement's failure to submit affidavits with the motion is fatal, and that in the anti-SLAPP is not a mulligan, there are no do-overs. You also say you will not consider the transcript. That leaves only the pleadings. And the Kansas Court of Appeals in Doe v. Kansas State University confirmed that the anti-SLAPP statute did not alter Kansas pleading rules. Kansas remains a notice pleading jurisdiction. So what does that mean? My well-pleaded facts must be taken as true. Defendants say my petition is filled with conclusory allegations.
And respectfully, I have a pink Solo cup on my desk, Your Honor, so you have to take what I say as true fact. Is that a pink Solo cup? I'm Canadian, but I know what that is. Was he playing beer pong? At a sorority? Jesus.
Every legal conclusion that they point to is tethered to a specific fact I pled. So let me walk through them for you, Judge. Retaliation, paragraph 26. I allege that Mr. Irby's protected speech was motivating factor in Ms. Gillette's retaliation, but this is supported by facts, paragraphs 9 through 13. The duck incident, the public criticism, the media coverage, and then immediately afterwards, Ms. Gillette filed an ex parte stalking petition and threatened criminal prosecution. Those facts provide the sequence of events. The retaliation allegation in 26 is not a naked allegation, but is a legal conclusion that flows from those facts. In paragraph 30, I pled willful and wanton conduct. I pled that Ms. Gillette acted willfully and wantonly with reckless disregard. That too is grounded in facts, paragraphs 18 through 24. She filed a meritless petition. She testified in ways the video evidence disproved. She used the resources of the prosecutor's office to pursue personal vendetta. Those concrete acts show deliberate and reckless misuse of authority. The willful and wanton language gives the legal characterization, but is supported by facts. Lack of probable cause, paragraph 32 and 37. I allege there was no probable cause. That is tethered to facts 21 through 23 and 27. The video directly contradicted Ms. Gillette's sworn testimony, and the court denied her petition. Those are hard facts that put defendants on notice of a malicious prosecution claim. As such, the lack of probable cause language is tied to those facts. Malice in paragraph 32, 35, and 36, I pled. The factual basis is again in paragraphs 18 through 24, false sworn allegations, controverted by video, use of her position as a prosecutor for private advantage, pressing for.
So this is the Jill Gillette, the prosecutor in this jurisdiction. What a wild little case. I remember she had somebody stalking her, Patrick. I remember that. She had somebody like showing up at her boyfriend's work for a while. And then there was something separate about that. But this seems like something else. This is post-judgment. So you have to understand that, unfortunately, I didn't catch the case as it happened, but I caught this. Oh, he has a YouTube channel dissing her? That's interesting, Ruth. Somebody find that link for me. I'd love to spend my Sunday night. We love free speech on YouTube. Yes, we do. YouTube daddy, don't smite me.
Despite the lack of any factual support. Those factual allegations show improper motive. The malice allegation is not standing alone, it's supported by what she actually did. And then what we call perjury allegations, paragraph 36 and 35. But those are tied to the specific false statements detailed in paragraphs 18 through 23. Compared against the video, I didn't just say perjury, I described the precise testimony and show how the video record proved it false. It was more than a label. It's noticeable what the testimony, what the evidence supported the claim. So, Your Honor, my petition contains legal conclusions, as every petition must, but those conclusions are not naked. They are anchored in specific facts, the duck incidents, the threats, the misuse of office, the false testimony, the video evidence, and the denials of the petition. That is the essence of a notice pleading. The facts give notice of what happened in the legal conclusions. And therefore, Judge, the petition allegations are all that matters. And those allegations then provide sufficient basis to deny the motion. There is no affidavit, there is no transcript, and my factual pleadings exceed the notice pleading. And so you have just with that, Judge, the motion should be denied on those grounds. And so I will leave it at that. If you have any questions, I'd be happy to respond.
No questions at this time, counsel. Mr. Martins, your response.
Your Honor, just briefly in response, I think it's important to emphasize in ruling on this motion that this is, although titled a Rule 165 motion, the gist of it is a motion to reconsider the court's prior ruling. And the case law is clear about the standard that applies to a motion to reconsider. There's got to be a change in the law, which isn't present here. There has to be new evidence previously unavailable, which isn't present here, or there has to be a basis to correct a clear error or prevent a manifest injustice. And so that's what the court's focus is here today, is determining whether or not its ruling was a clear error and would result in a manifest injustice. And as we laid out in the briefing, Your Honor, there's multiple reasons why there was not a clear error, with the most clear and direct being that the Doe case is binding precedent on the court, and it says that the court.
I might be responsible for some of that not clean air. Hashtag 420.
Must consider, can only consider affidavits in relation to ruling on a motion to strike. And because plaintiff didn't present those, then the court was correct in its ruling. There's some additional arguments that were made by plaintiff in the briefing that weren't addressed here today, including the potential unconstitutionality of the anti-SLAPP statutes, which to the extent that plaintiff is still relying on those, we addressed those in the briefing. And I do want to emphasize that we don't consider that a serious argument. I think that's probably evidenced by the fact that counsel didn't bring it up here today at oral argument. Specifically, though, the anti-SLAPP statute is a procedural remedy, no different than like a motion for summary judgment, in that the court is
Thank you, Mayor. Oh my gosh, look at Nathaniel thinking. He's like, can I become a member of the KCC crew? Yes, Nathaniel, you can, just like Mayor did. You can join us. We do members only. There's so many in the pipeline. In the backlog? I don't know how to say it. And thank you again, Mayor. Appreciate that. I'm excited to see your live stream from ModFest. That's right. Mayor is going on a cross-country journey of joy to see. Oh, it's 69. We love 69. Anyways, thank you again, Mayor. And his face has subtitles, right? That's a good way to put that. I like that.
Providing just a gatekeeping function and reviewing the evidence in support of a claim. So we don't view that as an issue. And again, counsel doesn't argue it here. And with respect to counsel's comments at the beginning of the hearing this morning, with respect to defendant not carrying an initial burden, that's something I did my best to search the briefing here as he was presenting an argument, but that appears to be, in my recollection, is an argument that's being presented for the first time in this motion to reconsider hearing, and it wasn't something that was raised in the briefing either. And as the court will recall from our hearing on the motion to strike and motion to dismiss, there was no dispute that the anti-SLAPP statute applied, and so for the first time in this hearing.
No, my hair is not wet, Mikey. Not my hair. Love that check mark every time. Nice to see you. Thank you for the Saturday night entertainment. And cellular yoga pants, you're terrible. Also, this case is about Jill Gillette misusing her prosecutorial power. A little interesting. Yeah, we should find the earlier hearings. I'm sure a YouTuber better than I has them somewhere in their little digital court hoard. But I don't.
Is defendant, or excuse me, plaintiff has taken the position that defendant failed to carry her initial burden in establishing that anti-SLAPP statute apply. And so the court can disregard that argument And so I think the court's ruling is correct based on the Doe case, and plaintiff has failed to provide a basis to reconsider or to change that ruling. Your Honor.
Mr. Baker and Mr. Martin suggest that you're arguing things today orally that you didn't include in your written memoranda that was submitted to the court in support of your motion. Your reply to that?
The idea, I did raise this issue in the hearing. If you recall, we had a great dialogue back and forth about when you ruled that transcripts weren't admissible. I said, well, then you've got the pleadings. Their burden is with the pleadings. I win. I said that at the transcript at that hearing. I said, if all you got are my pleadings, I win. They didn't sustain their burden. That entire argument was raised with you below in my opposition. They have the initial burden. And so I argued that. You said in that hearing, you said, well, I'm going to look at your pleadings, but then I find that some of them are conclusory. Now, in my motion to you today, Judge, or when I made it, I said, well, you didn't really explain, as I did today, why those are conclusory, that they were just simply naked allegations. You didn't give a factual basis for that. I have tied all those up for you today to say I did make legal conclusions, but each one was tethered to a factual basis. And based on that, Doe doesn't alter notice pleading. It doesn't convert, the SLAP doesn't convert notice pleading into plausibility or a fact pleading regimen. And so they say you look at the pleadings, and so that's what you did. I would say to you, Judge, that if you look at my pleadings, they're not naked allegations. Each one of those legal conclusions, as I said today, are tied to factual. And with that, then, with no affidavit, the Mahaffey court said, look, they don't sustain their burden at all. And that's what they relied on. They relied on nothing but that transcript. And so now all you've got are the pleadings. And McAfee says you're not going to sustain your burden if you don't have an affidavit. And they didn't have one. So you're left with these pleadings. The examination of them provide, Judge, and states they don't sustain their burden. And so I raised all these issues in my motion, opposition motion, and at the hearing, we had a great discussion about that. So that's my response to that, Judge.
Is Mahaffey cited fully in your memoranda that you submitted to the court, Mr. Baker?
I don't recall, Judge, but
well, would you go ahead just to make sure? I obviously that's not binding precedent on this court, but it could be persuasive, and I'm curious as to how that court reasoned in that matter. So would you slowly state that citation again?
I will. J.V. Mahaffey, and that's Mahaffey, 218 Cal App 4th, 1522, 1537-38, 2013. And let me, I'll kind of give you a background there, which is in Mahaffey, the defendants filed an anti-SLAPP motion, but did not include any declarations or affidavits with your moving paper. So that's similar to what we have here. But instead, they tried to introduce form declarations for the first time in their reply briefs. And the Court of Appeals said, no, you can't, that you're done. You can't do it. And so the general rule on motion practice, new evidence is not permitted with in a reply. And because the defendants filed no affidavits, the court found they failed to carry their initial burden under the anti-SLAPP statute. Motions were denied, and denial was affirmed on appeal. So I think it's on all fours, Judge. And it was a unique situation here because
the amount of innuendo in this case on all fours from below, Judge looks like he's at a seance on Halloween and he's summoning judicial officials from the past to help him make the decisions that need to be made. He literally, although I did see pumpkins at the grocery store today, so obviously the time is nigh, or no. Yeah, pretty much there's no time left until Halloween. But again, Timu John Travolta, it looks like he's looking off camera at a director for his cues.
Defendants relied on the transcript. I did too. You actually said, well, yeah, let's get the transcript. And then you found the Doe case. And then we were left with no affidavits. But the affidavit part is their initial burden, and they didn't sustain that burden. So I would urge the court to look at McAfee because I think it is informative as to the burden shifting in this SLAPP case.
Mr. Martins, have you considered the import of this Mahaffey case in California, which would apparently be construing a similarly worded statute?
Your Honor, no, I haven't. I'm trying to review it now, but I'm not seeing it as cited previously in the briefing, and so this is my first time reviewing it here this morning. And I guess without even reviewing it, the one comment I would like to make, Your Honor, is that the court, as we've discussed, is obligated to consider the pleadings and the affidavits. And I think what makes our situation unique and which allows the court's ruling on this issue to stand is on the face of the pleadings, while the court's not accepting all of the allegations or is not obligated to accept all the allegations in the petition as true, it was clear from the petition that the claims arose out of circumstances, that being a prior lawsuit that the anti-SLAPP statute applies to. And that wasn't disputed by the parties. And so having that part of the petition and there not being a dispute over it, I think the court is able to accept that allegation as true, or those background circumstances as true, without necessarily accepting all of the plaintiff's allegations, particularly with respect to the more detailed factual circumstances that they allege to support the claim. And that's where the affidavits come into play, and the reason why they need to support that. And so I do think that the court's ruling on it can stand based off of the pleadings itself too.
Implicit in your argument, Mr. Martins, is that Gillette had no burden of coming forward with anything.
Correct.
Mr. Baker, I think, disagrees.
I do, Judge. The SLAPP is a burden shifting. They face the initial burden, and that comes through an affidavit.
And what would that affidavit theoretically say, Mr. Baker?
Well, the affidavit say everything you've alleged in your petition is not true. Here are the factual allegations. Here's why it's not true. Things of that nature. And we have affirmative defenses and all those things. I mean, that's why that's why they file an affidavit, is to controvert or say, we've got these other factual allegations that overcome your petition. And that's where I would have to come back if they did that with my own affidavit. And then we kind of it's not a summary judgment, but it is that kind of shifting burden. But without that affidavit, they don't sustain the burden. That's what Mahaffey says.
But how would the court resolve that factual dispute?
In a SLAPP?
We would have competing affidavits.
SLAPP fights? They would do it with SLAPP fights? Hi, Sharon. How are you? Thank you for coming by again. I think SLAPP fights would be a good idea. How much does his watch cost, by the way? Looks fancy. Unless it is also from Timu. We don't know. We don't know.
Essentially taking an opposite factual view regarding the incidents that are discussed in the petition, how would the court resolve those credibility issues?
Well, you wouldn't. You have to accept my pleadings as well pled. it is not an evidentiary summary judgment kind of issue.
Mhm.
So on its face, you have to accept what I pled and what is said. The slap burden shifting is not a summary judgment kind of thing. And so all you're looking for is, for example, she, in her petition, she made many false allegations, completely false, about Mr. Irby going out into the courtroom, outside the courtroom, blocking her car, looking in her car. She couldn't get out. When the video says he did none of that. Many false allegations. That is sufficient if you accept that as a malicious prosecution. She had no facts to support what she said. But if you'll look at Mahaffey, the fact they don't have an affidavit, and now you're looking at my well-pled affidavit.
Are they saying McAfee? Like the computer system that's always expired on every PC? And yeah, Shardell, what is Nathaniel looking at? Like, bro, unless you have, even if you had like that many monitors, you need them better arranged. What's going on? That's Jill Gillette's lawyer.
Allegations that you have to accept as true. And this is notice pleading. Doe didn't change the notice pleading into a fact or a plausibility. But my petition does go beyond just notice, just beyond legal conclusions. As I said this morning, I tie each one of those conclusions into factual allegations. You have to accept that. And my motion urges you to look at that in that context. But they have not sustained their burden, therefore no burden shifts to me. They just haven't sustained it. We win. You can't come to the court without that affidavit. Now, that's what I think McAfee stands.
All right, Mr. Martins, I know you want to respond to that.
Yeah, well, I wanted to clarify my position on the initial burden issue is that can also be established by the pleading, in that we don't have an initial burden to present an affidavit supporting anything. And the statute, I think, contemplates that we would be, in a reply, be allowed to submit affidavits responding to factual allegations further, so that because the court is ultimately determining whether or not the plaintiff has shown a likelihood of prevailing on the claim based off of the pleadings and supporting and opposing affidavits. And so that's, I think that's what's contemplated by the statute, not that we need to submit an affidavit in support of the initial motion.
All right. I want to make sure that your position on this is clarified, Mr. Martins. Is it Gillette's position today that the anti-SLAPP statute applies to both claims made in this case? Certainly, the court's ruling, I think, made it clear in regards to the malicious prosecution claim. What about the abuse of process claim?
The anti-SLAPP motion applies just to the malicious prosecution claim. However, there is some overlap in that some of the factual basis for the abuse of process claim were also relied upon by plaintiffs in support of that malicious prosecution claim. So to a certain extent, it does apply. It applies to some of the same allegations, but I do recognize that the abuse of process claim is a separate claim from the malicious prosecution claim.
All right. Anything that you would wish to comment on based on the court's most recent discussion with Mr. Martins, Mr. Baker?
No, I mean, I think you'll get edified when you look at that Jay Mahaffey case and the burden. So your analysis will first say, did they sustain the burden? And if they don't, they lose, and the motion to strike should be denied. So I think that's the simple equation that I urge the court to look at.
And I think, counsel, we would agree that there hasn't been a whole lot of case law development under this statute. So obviously, any California ruling would have to be reconciled with what we do have in Kansas as far as established precedent. And I'm sure you would agree with that, Mr. Baker.
I do, and I think Doe looked to California. A lot of they looked to a lot of California cases. Doe did that, and so Doe didn't stand for the proposition that notice pleading gets turned into something else. And it certainly didn't say, and it does talk about the burden shifting, I think. So, but it's persuasive, and it's not in conflict with Doe. So,
Mr. Martins, would you agree with that?
That is not,
Well, you haven't had an opportunity. I think that's an unfair question. If you haven't had an opportunity before today to fully review the Mahaffey decision, that's probably not a fair question for you. I'm asking you to take a case you haven't fully read and processed yet and apply it to Kansas law, which exists. And that's, the court's really not going to expect an answer at this juncture. But with that said, this court will be taking the decision today under advisement. The court wishes to obviously review the California case cited today, apparently for the first time. And then I want to give Mr. Martins an opportunity to file a supplemental response based solely on your the application of the rationale of the Mahaffey case in regards to issues which exist in this case.
understood, appreciate it.
I think 21 days is a fair period, Mr. Martins.
Yeah, that should be.
Lawyers and
You are
judges
not
are so
required
generous
to
with their
submit an additional memo of any kind or submission of any kind. But if you do, that needs to be on file within 21 days of today.
Okay.
All right. Mr.
All
Baker,
right.
anything further at this time?
thank you for your courtesy, Judge, and letting me appear by Zoom because of those other circumstances. Very courteous of you to do that. Thank you.
You're quite welcome, Mr. Baker. Anything further at this time, Mr. Martins?
No, just for clarification of the record, I think we're all on the same page on this. We did file the motion for attorney's fees as well under the anti-SLAPP statute. Obviously, I think we need to resolve this motion first. And so I guess just to make the record clear that we'll reserve that for argument. That's
So noted, counsel.
Thank you.
Very well. Have a good day, gentlemen.
Thank you, Judge.
Thank you.
Nothing further. This matter will currently be in recess at this time.
And the Zoom meeting will be ended for all. Judge, you can't leave us hanging. That's terrible. You guys, thank you so much for being here. We had a great evening. If you're here for the first time, please subscribe. I'll be live again tomorrow, 6 Pacific-ish, which is like, what, 9 East? I'm sorry it's so late. But I would love to see you. I promise we'll have new court to watch. And in the meantime, do me a favor. Remember that I love you. And I'm proud of you. That's me. I'm proud of you. And I will see you in the next video. Okay, bye. Bye.
Ways down